Good evening, everybody. Welcome to Climate Change Lawsuits Are Here. Are you ready? My name is Stephen Wood. I'm a professor at Osgoode Hall Law School of York University. And on behalf of Osgoode, the first thing I'd like to do is acknowledge that we are on the traditional territory of several First Nations who have occupied this area over time, including the Huron-Wendat, the Haudenosaunee Confederacy, the Mississaugas of New Credit, and the Métis Nation of Ontario. The second thing I would like to acknowledge is the generous financial support of York University in making this event possible through the York Research Chair in Environmental Law and Justice. I'm the holder of that chair. And I also would like to thank Osgoode Professional Development for making possible the free webcast of this event. We are live in Toronto, and we are also being webcast. The event is being video recorded and will be available on Osgoode Professional Development's website within, I think, a couple of weeks for streaming, and will be made available on the website of the Osgoode Environmental Justice and Sustainability Clinic at Osgoode Hall Law School in due course when we figure out the technicalities of that. So this event is an international panel discussion on one of the current important developments in environmental law and in law generally, which is the increasing incidence of resort to the courts to seek justice, remedies of some kind for the harms being suffered as a result of changing climate due to anthropogenic greenhouse gas emissions. The way that this event is going to roll out is that in a moment I will give the podium to David Estrin, Canada's senior environmental law practitioner and an adjunct professor at Osgoode, my co-director of the Osgoode Environmental Justice and Sustainability Clinic, and also someone who has been, in recent years, very active on the issue of climate change and climate justice. David will set the scene for us in terms of global trends in climate change litigation. We will then have short presentations from some of the people who are directly involved in that litigation, starting with Andrea Rogers, who is now staff counsel with Our Children's Trust, and also, as our program says, is an attorney with Western Environmental Law Center, and she's based in Seattle, also works in Eugene, Oregon. She's going to speak about some of the litigation that Our Children's Trust is involved in on behalf of children and youth in the United States. Rhoda Verheyen, who is a lawyer in Hamburg, will speak about litigation that she is involved with on behalf of a Peruvian villager in relation to adaptation to climate change. There's a program change from what was originally advertised. We were to have Kristen Casper, who is counsel to Greenpeace International. She's unable to be here today, but Keith Stewart, senior energy strategist with Greenpeace Canada, will be here to speak to us about various litigation strategies that Greenpeace is pursuing and in which he is directly involved. We then have, by video link in Victoria, Andrew Gage, counsel with West Coast Environmental Law, who is going to speak about an initiative that West Coast is spearheading involving municipal governments and the possibility of recovering for the cost of adapting to climate change. And finally, Professor Chris Tollefson of the University of Victoria, who's here with us in person, and who has recently established a new environmental legal organization called CEL, the Pacific Center for Environmental Law and Litigation. He'll speak to us about some of their activity. We'll then have Q&A, and what we're going to do is collect questions from the people here in the room. Each of you has an index card. If you have a question, write it on the card and we will collect them. And then David will pose questions to the panelists. Those of you who are participating on the webcast should input your questions in the chat window of the webcast. We will collect those, and it's not that all questions will be posed, but we will pose as many of them as we can. And after the Q&A session, we're honored to have with us Dr. Diane Sachs, the Environmental Commissioner of Ontario, who will wrap us up with some concluding remarks. So without anything further, I'm going to pass the podium to David Estrin.
Thanks, Stephen, and welcome everyone. Are you as stimulated and excited as I am by the opportunity to discuss climate litigation with people who are in the trenches, in the courtrooms, trying to tell judges, hey, there is climate change and you should do something about it. Not only what we are here to find out what's gone on, but also what's going on and maybe where we should be going. And in most countries, I'm just wondering about the United States, however. No, I was just, I'm thinking politically. Sorry. Now, that's for, I can only say that because I know Andrea from other sessions of this topic. Last year, I arranged an event that brought Roger Cox of the Dutch Urgenda case fame into Toronto. We had a great public discussion about how that case or variations of it could potentially be taken forward in Canada. And of course, today is now an opportunity to continue that exploration of potentials, uses of domestic courts and tribunals, as opposed to, well, something that hasn't had much success, the international fora, because we desperately need abatement, of course, of GHG gases as well as other regulatory measures, and we have, a problem of dangerous climate change. So, where are we, and why are you here, and why is domestic climate litigation being brought? Well, very briefly, let me give you an overview. Basically, it's because, well, our statespeople and world leaders have recognized through signing on at the UNFCCC and more laterally the Paris Climate Agreement that they know that climate change is dangerous, that they know something has to be done about it. Very little effective action has resulted. And so even though states agreed in Paris, it would be, we have to limit it to the global temperature increase to less than 2 degrees C and preferably less than 1.5. The Paris Agreement contains no specific emission reduction targets and nor any specific deadlines to meet those targets, and instead, basically, all it comes down to, from my perspective, is a commitment for best efforts. So given the failure of states to stop this almost constant increase in GHG carbon emissions that has been going on while everybody was talking, and the worrying practical and legal gaps in the Paris Agreement, frustrated citizens, I think, are increasingly looking to their domestic courts, really, to require government to mitigate emissions and limit climate change. So there's 3 important cases that started us off, really, in 2015. There's the Urgenda case out of Holland. There is Andrea's case in Washington State, Foster in Washington. There's the Laghari case in Pakistan. We're really fortunate to have Andrea here to talk about that case, and then what Rhoda's going to tell us about a case that's really going on right now in Germany for a Peruvian person in Germany. That's very interesting stuff. Now, let me tell you just quickly a couple of interesting and important things arising from Urgenda and from Laghari, in case you're not familiar with the details. Urgenda showed domestic judges can get interested in these issues once they're made aware that, all governments have agreed, they've made some commitments that climate change is dangerous, and, that the climate science is there. Roger Cox did a great job of presenting all the stuff from the Intergovernmental Panel on Climate Change, and I think the judges really, and he helped them understand it. So when you understand that the science is really there, that it's vetted by everybody, all the top world scientists, and there can't be anything said in those reports that isn't agreed to by everybody, then, you know, you've got the best peer-reviewed science in the world, and so why shouldn't a judge be prepared to act on that if there is a legal remedy? The other interesting thing about Uganda was that the court was so I guess, wrapped up in this, that they were willing to, anyway, push the boundary. I mean, Roger Cox didn't go to court on the basis of constitutional rights per se, although he raised the Dutch Constitution. He basically he pitched the idea that the Dutch tort of hazardous negligence should apply in this case, that the Dutch government had a duty to citizens analogous to the tort of hazardous negligence, the leading case in Holland being one where a brewery person left the cellar hatch open and somebody fell down. And that was the leading case on hazardous negligence in Holland until Roger Cox said, maybe this is a case that, you know, it's analogous, let's go with it, and the court did. So, I mean, you know, if you can get the court interested, judges interested, that's very interesting. But of course, there's in other countries, constitutional rights, maybe common law. We're going to talk about all that. What's another very important thing about your agenda, and this I think is apropos of what happened in Rhoda's case just recently, is the argument was made by the Dutch court. Well, judges. Holland only contributes, I don't know, 3.3% or something to all the world's GHG emissions. So, it won't make any difference if we have to act. And the court basically said, no, that's not right. And let me just give you a quick quote if I can find it. This argument does not succeed. It is an established fact that climate change is a global problem and therefore requires global accountability. The amount of Dutch emissions is small compared to other countries does not affect the obligation to take precautionary measures in view of the state's obligation to exercise care. After all, it's been established that any greenhouse gas emissions, no matter how minor, contribute to an increase in CO2 levels in the atmosphere and therefore to hazardous climate change. Emission reduction therefore concerns both a joint and individual responsibility. I mean, even the U.S. Supreme Court in Massachusetts case, where the U.S. EPA was arguing, you shouldn't overturn what our decision is that we don't want to rein in car emissions. The court said, and they said, car emissions are just a small drop in the bucket compared to everything else. And even the U.S. Supreme Court said, that's not a valid argument. If we take that, again, everybody's going to be able to do it. And justiciability was another big defense that's always going to come up in these cases. And again, your Uganda case is really important on that. And again, let me just, and this is a great quote I think you need to be aware of if you're going anywhere on this stuff. With respect to the defense of non-justiciability, it rejected the Dutch government's argument it was improperly political for judges to review the appropriateness of government climate policy. The court found that if government has a duty to protect citizens from climate harm and is not doing so, a court may order it to reduce emissions. Quote, the task of providing legal protection from government authorities such as the state preeminently belongs to the domain of a judge. The claim does not fall outside of the scope of the court's domain. The claim essentially concerns legal protection and therefore requires a judicial review. This does not mean that allowing one or more components of the claim cannot have political consequences. However, this is inherent in the role of the court with respect to government authorities in a state under the rule of law. Well said. Couldn't say it better. So, Uganda's got a lot of stuff in it, but those are two key things. The Ligari case, it's so entertaining and important at the same time. A farmer brought a case in front of the Lahore High Court saying the state is not doing anything to implement its national adaptation plan on climate change. Pakistan doesn't have a lot of emissions, but they need to adapt. And the government brought in this huge plan, but the problem was that they weren't doing anything. And basically the pleading said the government was guilty of inaction, delay, and lack of seriousness. While the judge, within about a week of getting it on his docket, summoned all the deputy ministers of federal and the state departments into his courtroom and said, gentlemen, I think they're all gentlemen, tell me about this. The allegation is you're not doing anything. And so he heard them for a whole day, and at the end of the day he said, so I gather you're telling me you're not doing anything. And they said, yeah, that's about it. And they didn't have anything in their budget. And so he said, well, basically this is not going to continue. So I want you to, first of all, I'm going to order you to come back here in 3 months and tell me 3 specific things that you're actually done or going to be doing by the end of the year. And secondly, he appointed a climate change commission to assist the court to monitor the progress. Well, at one of the hearings, the cabinet secretary came in and said to the judge, well, you know, the cabinet shouldn't have to do anything on this unless it's informed by the Minister of Environment and Climate Change. And the judge said, that's a lackadaisical approach, quote unquote. And he basically dived into the Pakistan Constitution to reason that there were constitutional duties on the government, both federal and state, to act. And what he said is, again, a ringing sentiments, which, you know, he said, basically, climate change is a defining challenge of our time and led to dramatic alterations in our planet's climate system. And he went on to say how it would impact Pakistan. On a legal and constitutional plane, this is a clarion call for the protection of fundamental rights of the citizens of Pakistan, in particular the vulnerable and weak segments of the society who are unable to approach this court. And then he went into the Constitution of Pakistan talking about fundamental rights, and he basically said, well, we've already developed environmental rights and environmental justice. We have to, that was largely localized and limited to our own ecosystem and biodiversity. We need to move to climate change justice. And he went on. So it's a ringing endorsement. Basically, oh, and I got to tell you one more thing. So some journalist interviewed him, and the journalist observed this, that this case probably cost less than a week's stay in bond for Pakistan climate negotiators. Justice can be swift. And so, you know, if you get the right judge in the right case, yes. Anyway, to sum up, in the face of government inaction, domestic judges may be induced to use and even adapt traditional domestic remedies and constitutional rights to consider international law principles. Many judges, I think, will want to be part of the solution rather than another roadblock. If this emerging trend continues, it would demonstrate that at least the judicial branch of government can effectively act on this wicked problem. I mean, some cases are going to be unsuccessful. Litigation still plays an important role. And, you know, lost cases can still underline the fact that there's public concern and that the planet faces chaos, climate chaos, unless we act. So my last sentence is this. Thus, both successful and unsuccessful citizen domestic cases on this issue can be a positive force to ensure that political leaders do not continue to spout greenhouse gas reduction rhetoric at annual UN meetings in fashionable locales. Wow. Okay, so we are on to our first real speaker, Andrea Rogers. So there you go. You want to come up here and I'll move away?
Real speaker.
And we have a PowerPoint.
Yeah, I think so. You do. And you want a glass of water?
Not that one. That's Rhoda's.
No. Oh. Is somebody else doing it or are you doing it? I can't remember.
Which one is yours? Is that enough? No, it's not.
Let me get my laptop and then I could use it as an outline. Sorry, everybody. Technical difficulty.
It didn't show up?
Well, you can't select?
Let's switch to Rhoda.
Yeah, switch to Rhoda.
Okay.
Okay, switch
Sure.
to Rhoda.
Yep. Okay. There we go.
We'll have to turn around to see it.
Okay, that works. Hello. Oh, I hope that wasn't me. I normally don't have that effect on children. So, okay, so thank you for having me. I'm not going to introduce myself again because that's just going to take up time. I'm a practicing lawyer, environmental law lawyer, specializing in this, and I take a very special case at the moment in the German courts, and I will tell you about this case only, and if there's any in-depth questions, that will have to wait until Q&A because we simply only have 10 minutes. So I will try and rush through this very briefly. And those are all my wonderful colleagues up there. So. There you go. So the case I'm currently taking is about Peru. It's impacts in Peru that I'm concerned with. This is the city of Huaraz. This is a blue arrow. It's a city which is basically in the tropical Andes of Peru, and it is a country that is very threatened by glacial outburst floods, but it's also very dependent on the water that comes runoff from the glaciers for agricultural reasons. So it's glaciers are very much part of tradition and of life in Peru. This is the lake that actually concerns my concrete case. This is the Laguna Palcacocha, and there is, as you may not immediately see, but you could see an acute risk of a glacial outburst flood. The glacial lake outburst floods are probably the first potential impacts from climate change that the IPCC has recognized already in its first assessment report in 1990. And we're now at a stage where about 500 glacial lakes around the world are actually just simply filled to the brim and about to burst. And one of them is this one. You see the development of the laguna here in this picture. I think it's quite nice to actually show this, because what you see is that it's not simply more water. The glacier is actually retreated, and that is consistent with the science. It simply says that the rising temperatures actually lead to glaciers retreating, making more space for the lake, but at the same time actually putting extreme pressure on the moraines, that the kind of the walls of these glacial lakes. This is only 2009. If I were to put a similar picture of today, it would even be bigger, but not exponentially bigger. This is basically the kind of picture you have today. This is a flood risk map of the city of Huaraz. The yellow arrow is my client's house. I don't have to explain this map to lawyers. Where it's red, there's a high risk, and it's an acute risk. This is a provincial statutory declaration on the flood risk of Huaraz in these particular areas. So what would happen if the flood would actually hit is simply all of these places would be completely flooded, and the most dangerous is not just the water, but the actual mud and the brick and everything else that would come sliding down. This is my client. His name is Saul. He's a very brave person, and much braver than I am. He lives in this house, which now looks different because we've actually been able to reinforce it with brick. This is only clay. And he takes this court case with the support of this German NGO, which is called German Watch. And you can see you can find all the files and the filings, briefs, and also the judgment on this website in due course, also in English. Right, so where did we actually start? My client, together with, and as always, this is a lot of coincidence, but he basically got in touch with a lot of people in his country and then with German Watch, and they looked at this IPCC assessment report, which they had already referred to. And actually, the science on the tropical Andes is one of the best there is. So the IPCC says tropical glaciers retreat. It has accelerated immensely. The reduction in tropical glaciers and ice fields in the extratropical and tropical Andes can be attributed to an increase in temperature. And there's a very high degree of confidence, which means 90 to 99% confidence, that this is climate change. So this was my starting point when he came to me, and he basically wanted to do something about the risk. Now, you can see that there's probably many ways to actually do something about the risk. So what we first did was went to climate funds or adaptation programs and even development aid agencies. But the fact is that a single person who thinks he's actually affected can't claim anywhere. That's a simple fact. So we had to look on the actual civil law plane. So we looked at who is in actual real contributor to climate change, and that is the defendant. And RWE is one of the 4 major energy companies. It burns hard coal and lignite, and it still mines today, actually displaces people still today. It is one of those declining companies. It has registered a huge loss, but it's still one of the 4 major coal-burning industries in Germany. And that is very important for this case. It is Europe's largest industrial emitter of CO2. It is responsible for 0.5% of historical emissions. That sounds very little, but it's the same as a country such as the Netherlands or Belgium. And and I said there in the slide, I actually say this is the same share as the country of the Netherlands, and it translates into more than 5%, 0.5 of absolute temperature response. This is important because I'm not only talking about the emissions, but I'm actually talking about how can I relate this back to what actually happens on that mountain up there, and I can. So, and the share of responsibility has not changed. So we then went and looked, so what can we do? And it is obviously nothing that has been done before, in Europe certainly. There is one case in the US, which is well known to students of environmental law probably, or tort even, the Kivalina case, and that is to my knowledge the only one that's ever been taken on this particular ground. It's a nuisance type provision. I say nuisance type because in Germany we don't actually have this differentiation between tort and nuisance as you may have in common law systems. And it's not a public nuisance. It's really you against me. It's really in the civil law code. It doesn't have anything to do with the state or anything like that. So I just tried to properly translate this provision for you. So if property, he has a house, is interfered with by means other than removal or retention of possession, so I don't just sit in your house, but I actually do something with it, the owner may require the disturber to remove the interference. And that is exactly what I do. I ask the RWE to remove the interference. And the motion, I put the motion down there. I hope that's even the right word for it. This is important because it gets really difficult. And why? Because I asked RWE not to remove the interference as a whole. I only ask RWE to actually take responsibility for its share of emissions. So I ask, the motion is to determine that the defendant is liable, proportionate to its level of contribution, to bear the expense for appropriate safety precautions. And I have to say, at this point, I think I have about 16 motions in this case, because it is very difficult to actually get them to be precise enough. So all the facts are disputed, as well as all the legal prerequisites. We filed this case in 2014 on the 24th of November. And then we kind of entered into this written phase. And everything was disputed and still is. The only thing that was actually not disputed is the applicability of German law. So nobody actually even contended that. And that's because we have the Rome II regulation, which is EC law, which basically says that you can choose if you're an affected person. So I won't read all that, but you can read for yourself. Applicability, foreseeability, burden of proof, causation, of course. Everything is totally disputed and nothing was admitted by the defendant. And as well, the remedy, the possibility of even getting a remedy was disputed. So here are we. Actually, on the 24th of the last year, we had the oral hearing. This is only German press. There was a lot of international attention to this case as well. So we had a very long hearing for a German court, discussed mainly causation and a bit of foreseeability issues, but mainly causation. And I lost. On the 15th of December 2016, I actually got the verdict that they would not even let me actually move to the evidentiary phase. So I could not prove that this is climate change. I could not prove that there is a risk, simply because they rejected the claim on the basis of legal matters. So what did they actually say? They said that these motions aren't proper remedies. So that's very procedural stuff. We could probably get into that with, I don't know, with scholars of civil procedure law, which I'm not. But most importantly, they said there is no legal causation. And every lawyer, I think, in every country knows the but-for test and the sine qua non formula, as we say. And they basically said, you don't cause anything, because if you take away those 0.5% of emissions, the risk is still there. But I never argued that, of course. I never said that if you were to remove RWE's share of emissions, there would no longer be a risk. I argued that the specific risk would no longer be there. That is a decisive difference. We do not have very much jurisprudence on this issue, you have to understand, because especially in environmental law, all the things are regulated. So this is something that's actually going to advance, in my view, and I'll come back to that, understanding of multifactual or multi-causation instances or damages. So I say wrong. This is a case of causation on the basis of partial contributions, which are proven. Nobody contends that there's emissions, and there have been for decades. And so the but-for test can only be applied if you actually look at the very concrete risks that's there. And then also what David also already mentioned, the insignificance. This court actually said in one sentence, that this major energy company, I remind you, it's Europe's largest, biggest CO2 emitter, is only insignificant in terms of its contribution to climate change. One sentence. So I actually think that that cannot stand. That's the one thing I'm pretty sure that will not stand. It's wrong. It's simply wrong. There's no threshold, and if there was a threshold, it would have to be decided by science and not by no threshold at all. So this is the actual judgment on the left hand, and the appeal has been accepted. I'm going on to appeal to a high court, state high court. The timeline procedure is up to the court because that normally comes as the first question. I don't know when the hearing will be, maybe this year, maybe next. It really depends on whether the court is willing to hear the argument, and I do not know that. The appeal must show a significant error of application of law, and as I said, I do think I can show that. I've already submitted the briefs. The appellate court must accept facts as found by the district court, but since we didn't actually move to the evidentiary phase, we would, we would have to be referred back probably. I submitted lots of expert statements, all from IPCC scientists. They would stand, but they would be, subject to possibly a attribution study that could be commissioned by the court itself. And that in itself would be very interesting. How would the court actually do that? And who would the court actually commission as a scientific expert? Issues of general importance with this case, apart from the, and I was completely overwhelmed by the response. I think I have done nothing but give interviews for, for weeks on end. I had no idea this was going to have such a huge impact. Also with the international press, so I feel that there's a huge interest, and actually journalists are not coming to me anymore saying, you're crazy, but they're now coming to me with the question, so when is this going forward, what will you do? It's the kind of the approach has changed entirely, and the general importance issues for me, at least from a civil law perspective, is really this find causation in instances of partial or contributory causation. And in the end, it comes down to this citation that I always use. The Trill Smelter arbitration is one of the leading cases in international environmental law and actually is applied in many, other kind of statutory provisions and things, and says, it will be enough if the evidence shows that the extent of the damage as a matter of just and reasonable interference, although the result may only be approximate. And that means that causation in such instances will actually just have to be shown to render a just result. And what is the just result? That remains to be seen in my case. The role of uncertainties is another one. If I had more time, I would actually go into detection attribution, this whole area of science where climate scientists actually try to show the climate signal and the human signal. This plays a huge role in my case. And I have to actually use a standard of proof that is full. I cannot just say more probable than not. So that is going to be very interesting. As I said, I haven't actually been able to stand on, kind of do the trial and witness stuff. And IPCC findings as reasons for reversal of proof. I'm actually saying what the IPCC says is true. And you, court, you cannot refute that. Who knows better than the IPCC? Nobody on earth, I argue. So if they actually agree with me on that, that would be, I think, of immense importance for anybody in the world trying to take climate change cases. And that's it. Sorry for trying to.
I'm sure we're all pleased to hear that Rhoda is upbeat and feisty for the appeal, and can't get any worse because that case was argued in the home district court of the polluter. And they probably employ a lot of people in that area, so it can only get better.
But our judges are not elected.
You're not?
No.
No.
Probably good.
Yeah, exactly.
Okay, Andrea, I hope
right.
we're lined up to have you tell us all about the important litigation you've been successful at so far.
All right. Hello, everybody. Andrea Rogers. I'm an attorney from Seattle, Washington, and I'm here to talk to you about our atmospheric trust litigation that we have going on in the United States, in almost all of the 50 states in one way, form, or another, and then also in several different countries. I'm going to focus on the federal case. There are different nuances of the same theory, but here our clients are youth, and that is what brings, and one of the things that unites all of the different cases that we're bringing is that the cases are brought on behalf of youth. And here is one of my clients. His name is Aji Piper, and he's 16, and I've been representing him for about 3 years. A remarkable young man, and this is just a quote that he had in the press. But one of the things that I love doing this work is because of the kids. I mean, they really are amazing. They're very sophisticated. They understand the science, they understand the law, and they are so committed to seeing change happen and to protect their rights. And there's Aji. They're talented in many ways. This is before one of our court hearings. A big aspect of our case is that the government has known, the sovereign governments have known for many years about the climate danger that we're facing. Here is just a few examples of evidence that will be presented in our federal case regarding the U.S. government's knowledge of the climate danger. And I would imagine most governments, including Canada, will have similar documents showing knowledge of climate change. It's a long time coming. Scientists have been working on this for many, many years. And, you know, we start to see things, these are just pulled out of some government reports that will be part of our case, but you can see the timeline going back to 1955. And in our case, the federal government has admitted that the government knew of climate change and the dangers that it presented for at least 50 years. So it's quite remarkable. Similarly, we have the same thing in Washington State. We have documents acknowledging the climate danger, acknowledging the need to act, but we don't see the other side of that, which is action requiring greenhouse gas emission reductions. I like particularly this last, the 2014 report, where they say we're imposing risks on future generations. We viewed that as an admission. And we use that as evidence in our Washington State case. And I think the judge was quite taken with that when the state recognizes that their conduct is burdening rights. The legal theory, and this is, you know, this is where professors come into play. The theory we are implementing in court was developed by Professor Mary Wood, who's a law professor at the University of Oregon. And she's very familiar. She worked in the areas of Indian law and environmental law, and is an expert on the public trust doctrine. And she had come to realize through reading all of the unsuccessful climate change cases based on our statutory laws, which are great. U.S. has wonderful statutory environmental laws mandating the elimination of water pollution by 1985, pesticide regulation, Clean Air Act. We've got great statutes, but they have not been implemented in a way that has actually protected the environment. What has happened is they have delegated authority to these agencies who do not implement them in the way that they are designed and instead are issuing permits to pollute. And climate change, because it comes from so many different sectors and is such a hard problem to handle as a regulator, has really escaped notice of these statutes. And so that's why she started developing this legal theory. And here's the framework. And this is not just a notion that's in the United States. Many people will refer to it as a natural law. Originates in the Code of Justinian. But the theory is that sovereign governments can hold essential natural resources in trust on behalf of present and future citizens. I don't know if you've heard of the concept, the tragedy of the commons. Well, when we all share certain resources, it's a good idea to have rules as to who gets what so that you don't completely deplete the resource. That's what the public trust doctrine is about. It's about ensuring that the resource perseveres so that future generations can continue to access, use, and enjoy those resources. An important part of this is an attribute of sovereignty. So it's part of who the government is, and it does not go away. It's not something that the government can legislate away. They certainly can regulate natural resources, but they can't give them away entirely. And the leading public trust case in the United States is the Illinois Central case, which is cited there, where the city of Chicago gave up the entire harbor to a railroad company. And the U.S. Supreme Court said, you can't do that. The public has certain rights there that are protected. So our goal in these different litigation cases that we're bringing is we're trying to invoke the judiciary's role in protecting the rights of young people. Why are we going to the courts? As you know, the executive and legislative branches have failed us. We're seeing that even more so today with our recent election. You know, we're not expecting any very aggressive climate legislation coming out of the United States. I don't know if any of you are gamblers, but, you know, I would put your money on not passing many strong climate protection laws from the U.S. anytime soon. So we're asking the judges to step in, giving the harms and the dangers and the infringement of rights that we're experiencing here. We're asking that they declare the rights of young people. Do young people have rights, constitutional, fundamental rights? And how it's been framed in our cases is to a clean and healthy or a stable climate system. Do they have a right to that? And then we're asking that the judges order and manage a remedy, and that's where we're desperately trying to get. That's probably the most important part of that, is that the judges oversee the government bodies that are implementing these remedies, because that's desperately needed. Another key part of our case is the science. Our lead expert in our cases, we have many, is Dr. Jim Hansen. Many of you probably know. And he and his team have done a tremendous amount of research and work in terms of what is the safe level of carbon dioxide, concentrations of carbon dioxide in the atmosphere. You know, you'll hear numbers 450 that is coming from the IPCC. You hear 2 degrees. And what his team has opined is that the safe levels where we need to get down to is about 350 parts per million. Could it be 340? Could it be 360? Probably. But the best evidence using the paleoclimate and the modeling that they've looked at is 350 is where we get to safe levels and where we can preserve humanity as we know it. The real key here is the loss of the ice sheets and sea level rise. Because once you get that, that's where we lose most of our coastal cities, and along with the other impacts. But that's really what they're most concerned about, or what are those tipping points so that the sea level rise, because that really changes the ball game for us. So in order to get there, you need to do massive greenhouse gas emission reductions. And then the thing that nobody ever talks about yet, because it's so hard, is carbon sequestration efforts. So what we are doing to our children is we're essentially putting them in the position of having to figure out how to sequester massive amounts of carbon, even though we don't have the technology to do that. So that's why at this point we need to start doing that in the form of agricultural and forestry efforts. And here I just, I'll quickly go through, I'm not going to go through, my case in Washington is the most procedurally complicated case known to man. Rhoda mentioned all of the motions that she filed. I mean, we've filed motions that nobody's even seen before. Permission from the Court of Appeals to rule on this and that, and 60B and contempt and everything. But it comes down to, we got a great ruling in November of 2015. We lost in that ruling, but then we later won. We had to go back to court, and we got an order directing the agency to cap and regulate greenhouse gas emissions. But this case made several important findings in terms of the law, most notably that the public trust doctrine is enshrined by the Washington State Constitution. And these words are very inspiring coming from a judge, that the time to act is now. We have a responsibility to protect our children before their survival is at risk. And so she really recognized, and in our case, the science wasn't disputed. Ecology has recognized the science. And again, here are some of the state's legal obligations. These are constitutional obligations to affirmatively act to protect our public trust resources. And this is a mandatory duty. And it's not exclusively coming from the Constitution and the public trust doctrine, but also in statutory law. Statutory law directs our state agency to protect air quality on behalf of present and future generations. Well, we're arguing that that's something you can measure. And when you have all of the scientists saying that we're facing catastrophic climate failure, we're not protecting air quality for future generations. So these are things that we can prove. Now, the biggest case that we're working on is against the federal government. So, and what I like to tell people when, we get nervous that we have President Trump, I mean, one thing to make people in America feel good is that he's a defendant in our case. So if that makes you feel good at all. But this, again, is an unprecedented constitutional climate rights case. And this is not an environmental law case, as the judge in the case has recognized. This is a constitutional case. It's alleging that the federal government, through its affirmative acts and omissions, so we're not saying that the government has simply sat idly by, they have taken affirmative acts to addict us, essentially, to fossil fuels. And so we have a number of different allegations about how the government has tied us and put us in the situation that we find us. Now, as opposed to the case like Rhoda was talking about, the U.S., they've emitted quite a bit of greenhouse gas emissions. So they're a big player in this. And I think that is one of the facts why the judge recognized that the courts can step in here, and this is implicating constitutional rights. Again, here's and some of the beauty of these cases are just what the judges say. I mean, it's really inspiring and quite remarkable that they're stepping to the plate and recognizing that they have a role to play and an obligation to enforce the rights and protect the rights of young people. And here again, and this is one of the key holdings in the case, is that it's a fundamental right. You have a fundamental right to a stable climate system. And so she recognized that. We have a nice jurisprudence in the United States about fundamental rights. Most recently, the gay marriage issue that was addressed in the U.S. Supreme Court was considered to be a fundamental right. So we have that in other contexts. Now we have it in the climate context. And again, she recognized that there's a federal public trust doctrine. This was quite hotly disputed because public trust cases are generally litigated in the states, in state courts in a matter of state law. But here, the federal government does have jurisdiction over this. And I don't have to say anything except what the judge said. I mean, typically PowerPoint presentations, you don't want to just read what's on it, but I have to. This is so good. This action is of a different order than the typical environmental case. This lawsuit may be groundbreaking, but that fact does not alter the legal standards governing the motion to dismiss. Indeed, the seriousness of plaintiff's allegations underscores how vitally important it is for this court to apply those standards carefully and correctly. Federal courts too often have been cautious and overly deferential in the arena of environmental law, and the world has suffered for it. I think it's very clear that that is the case, and we feel strongly that taking these cases to the courts is really the only way we're going to protect our kids and our future. And the last thing I'll say is this is a tremendous opportunity for the youth. They're learning, they're in court, they're advocating, they're testifying. I mean, feel good to know that this is the next generation of leaders. Our generation may have not done what we needed to do to solve this crisis, but the kids coming up are certainly going to be much more equipped to handle that, and we're real pleased that we get to represent them. So thank you.
That's really amazing litigation, amazing success you've had so far, and keep it up. It's really great. Keith, come on up and tell us what Greenpeace is up to and making trouble all over the place on this issue.
So first of all, I'll apologize if you came to see Kristen Casper. Instead of the really smart lawyer, you get the pedantic political scientist. But I think there is a real interaction between politics and the law in this field, and we're in fact trying to use the law to change the politics of climate change. I want to say these legal cases don't take place in a vacuum. And we look south of Trump and we get a little scared, but I just want to remind you that change is coming. There is a vibrant and growing movement to keep fossil fuels in the ground. Indigenous people are protecting communities and the planet from destructive oil and gas interests and projects around the world. The divestment movement is challenging institutions, individuals, and governments to show climate leaderships, aligning their investments with their values. And we have distributed renewable energy systems that are blossoming around the world and, in fact, killing coal through the markets and not just through the law, though we want to do that too. So for Greenpeace, our work on sort of law and climate change really has sort of three aspects to it. I'm going to focus today on the second, but we also We're still fighting those ever-mutating forms of climate denial, and oh my God, are the Americans good at creating them, I gotta say.
You're welcome.
We're also looking at forcing market transparency with the aim of changing investment to flow away from fossil fuels. But today I want to talk about the one we call co-powering communities to hold governments and corporations accountable and legally liable, with the aim of aligning national climate policies and business plans with the Paris Agreement's 1.5-degree target. We basically want to force unburnable fossil fuels to be kept locked deep underground and allow radical solutions to take hold, and we need the law to help us do that. There are cases around the world. There are climate leaders happening all over the place. Momentum is building in hallways of power, in corporate boardrooms, on the streets, front lines, linking climate change, human rights, and governmental corporate responsibilities. I'm going to focus on 3 cases today. One in the Philippines, one in Switzerland, one in Norway that Greenpeace is involved in. The first is in the Philippines. This isn't a traditional piece of litigation. What we've done is we've gone to the Commission on Human Rights in the Philippines. There are 14 civil society organizations, including Greenpeace Southeast Asia, and 18 individuals who filed a petition with the Philippines Commission on Human Rights. They brought that petition to them because they believe that the fossil fuel producers should be held accountable for the human rights impacts of climate change and ocean acidification. We're using the work of Richard Head, which has also been referred to sort of identify which corporations are responsible for how much historic emissions. Very important to actually have some of that sort of causality. This is the first ever climate change related complaint accepted to a national human rights institution. It's also the first to be fully accepted by a Human Rights Commission and the first to implicate private actors in alleged human rights abuses. So we're basically trying to say that corporations are committing human rights abuse by failing to change their business plans to address the climate threat. It was first announced during the Paris climate negotiations in December 2015. In July 2016, the CHR served the petition to 46 carbon majors, 46 large investor-owned companies who are jointly responsible for 21.6 of estimated global industrial emissions. At the moment, we're keeping this to the investor-owned ones, not the state-owned ones, just for keep it somewhat manageable. And if you look at, oh, no, you won't look at it because I haven't clicked yet. On that list of logos, you'll see that there's actually 4 Canadian companies. Suncor, Canadian Natural Resources Limited, Encana, and Husky, all major players in the oil sands. The legal basis. We know what the historic carbon emissions are, what kind of a contribution they're part of, and this, over a fifth of global emissions is a big chunk. We have the evidence that has also been referenced of the damage that this is causing. And we're saying that these investor-owned carbon majors have breached their responsibility to respect the rights of Filipino people and communities by directly or indirectly contributing to the current or future adverse human rights impacts through the extraction and sale of fossil fuels and activities undermining climate action. So it's not just emissions, but also their political lobbying strategies. If they are lobbying governments to not act, then that is basically insult to injury. So we're saying they have a responsibility to avoid causing or contributing to adverse human rights impacts, and they are failing to act with due diligence in light of the known risks posed by climate change. And we've documented all of this, and we have the individuals who are bringing forward how they've been impacted. Philippines is, of course, one of the countries that has had the least contribution. Their emissions are very small, but they're getting hit by these superpowered typhoons on a regular basis. So they're one of the places which is regularly getting hit. They're also, of course, it's an archipelago. It's islands everywhere you look, and so rising seas are a major threat. So what do we want? In the language there, it's called the prayers. What are we asking for? Important to note, we are not seeking damages. We're explicitly not asking for them to pay the costs. There's a number of things where we're asking the commission itself or the Filipino government to monitor and record, But specifically, I think, from an international perspective, we're asking the companies to submit plans on how such violations or threats of violation resulting from the impacts of climate change will be eliminated, remedied, or prevented in the future. We're going at the companies and saying, what's your plan to stop causing these harms? So the questions we have for the companies are basically, what are your policies on assessing, preventing, and remedying human rights impacts resulting from climate change? What are your policies on climate change internally? Are they aligned with the Paris Agreement and human rights responsibilities? What is your energy demand forecast? How are you going to change your business plan? How are you lobbying on climate change? The corporations themselves are fighting back. They're basically saying, you don't have jurisdiction. Well, they're actually assuming that this is a court thing, and they're sort of using rules on jurisdiction in courts, but that doesn't apply to the Human Rights Commission. So you can go online. On February 14th, we replied to the 21 companies who have responded, most of them saying you don't have jurisdiction. But we're also sort of quoting back at them their own policies on human rights, on environment, to say your response to us is not consistent with what you say your policy is. So a second case, actually inspired by the Urgenda case. In Switzerland, there's 600 women aged 65 and over who sent a formal legal complaint to the Swiss government. Coming from these women because there's no, you can't do Swiss law prohibits lawsuits in the name of the public, which is why you have to focus on plaintiffs who have a specific concern. And in this case, it's saying heat waves, some of these other impacts affect elderly women disproportionately. They have a special case. They're saying the state is failing to protect their basic rights through the Constitution and through the European Court Commission on Human Rights. So I won't run through all the specific things, but they're basically saying, so the state, you have omissions that you have to remedy. You're violating the Swiss Constitution on the sustainability and precautionary principles, right to life. And so what we want is remedies, implement measures within these governments' competence to achieve the reductions of 20% by 2020, although they also say that isn't enough, but they're saying, you've already agreed to that, you have to do that. They've put out, here's some specific things we should do, things like state-of-the-art building standards, tougher vehicle fuel efficiency standards, and increasing the carbon price. We actually think similar cases can be brought in other jurisdictions. It's one of the areas where there's sort of there's room within other constitutional rights, et cetera, to try and expand these. And these women are really keen on pushing this forward. It's something they want to do for their grandkids. So thirdly and finally, in Norway, Greenpeace Nordic, which is all the Nordic countries, and the Norwegian organization Nature and Youth, it's a youth organization, Youth Again, are challenging drilling rights that have been given to Statoil, the state-owned oil company, in the Arctic. We're alleging that the licenses infringe on the Norwegian constitutional right to a healthy environment for current and future generations, that they contravene the Paris Agreement, the goals of the Paris Agreement, and constitute a breach of other international environmental and human rights law obligations. So basically, these 13 companies got these licenses in the far Arctic. The Arctic is, of course, disproportionately affected. It's particularly vulnerable. And so we started suing the Norwegian government in October 2016. The case will be heard in November. And we're actually pretty optimistic on the fact we might be able to make the Paris agreements binding, basically saying the Norwegian government can't issue these when they're so clearly inconsistent with your international commitments in Paris. So that's also very exciting. And again, there's lots of details on the various websites. You can get more from Kristen Casper, who's sort of helping coordinate a lot of these efforts. But we're also really excited. We're working with a bunch of other groups doing different cases. I think these things are popping up all over the place, and they're just going to keep mushrooming up, and the pressure is going to keep building. And sort of if we can keep this kind of synergy between legal action, between changing the politics, and providing this a way for people who really care to actually have an impact. You can actually bring forward a legal case. That's going to be really empowering, and I think it's going to help change the politics of climate change. Thank you.
Thanks very much, Keith. It's good to see what Greenpeace is inspiring and actually doing. And now we're coming a little closer to home. We're going to go to British Columbia. And Andrew Gage is going to be our next speaker. And he's done a lot of things as an environmental activist as well as an environmental lawyer. He's been to Paris and to the UNFCCC many times. And I think he'll have some interesting things to tell us about. I hope. I haven't talked to him for a few months. So go ahead, Andrew.
Can you hear me?
Yep.
Yeah. Hopefully you can all hear me. Yeah, I'm here to talk about the Climate Law in Our Hands initiative. On January 25th of this year, 55 groups from across British Columbia, including some national groups that do work in BC, sent a letter to all of the local governments in British Columbia, asking them to take action to hold the fossil fuel industry accountable for climate impacts that are being suffered by those communities. Here's a shot of the letter, with many of the logos. The logos all spill onto the second page. And basically we really emphasize the impacts that are being suffered here now and are going to be suffered, the BC communities are going to be suffering, and the potential that if we can just demand that the fossil fuel companies pay even a small fraction of the climate costs associated with their products, that they wouldn't be able to outcompete renewables. They would have to look at alternatives, and we would have a very different society when those externalities are internalized. So why did we do such take such a stand and really throw this issue to the local governments in this way? Well, first and foremost, I mean, I should say the two things we've asked them to do are to actually send a letter demanding accountability from the companies, and secondly, consider litigation. But why did we do this? We want to start a conversation because I think it's clear that the way we've been thinking about climate change does not help us solve the problem of climate change. I can't see the audience, but unfortunately, quick show of hands, which I won't be able to see, but just look around. Can you? How many of us have heard the line? So you're concerned about climate change. Do you drive a car?
Yes.
Most of the people in the room, Andrew.
Yeah, I mean, it resonates. We've all heard this. And yet this hasn't been a conversation in most environmental problems. For those of you who are old enough to remember the conflicts about the ozone layer and the fighting to prevent the hole in the ozone layer, does anyone ever remember being told, oh, so you're concerned about the ozone layer, do you own a fridge? That wasn't a thing. But somehow the guilt has been put so squarely on the individual in the climate debate that we all judge ourselves about whether or not we're doing enough. We judge others. We think that it's not appropriate, somehow hypocritical to talk about climate change when we're trapped in the system where we really have very few choices. Not all of us can afford electric cars. Not all of us can afford low energy alternatives, and certainly in those of us that are in the room right now are a relatively privileged bunch, and compared to many people, we have a lot more options, but even we don't feel that there's much that we can do here about this. But there are entities that can. Keith and others have referred to Rick Heaty's work, the Carbon Majors work. This is an advertisement from 1962 by Humble Oil, which is the predecessor to Exxon. And in 1962, they were boasting that they were producing enough energy today to melt 7 million tons of glacier. And that was generally viewed as just being ironic, just this weird fluke that they took this image. But in 1957, Exxon scientists were publishing materials grappling with the reality of climate change and disputing about how quickly it might occur, but essentially accepting the science. We have, this is the carbon majors that Keith was referring to. We have 90 entities that are responsible for almost 2/3 of the historic greenhouse gas emissions. And some of them are responsible for relatively large amounts. I mean, RWE, as Rhoda said, is responsible for 0.5%, but Chevron is responsible for about 3.5% of the emissions in the human-caused emissions in the global atmosphere, both from the direct operations and the operations of their products. So currently, we're expected to pay for climate impacts. We're expected to build higher seawalls or bail people out when there's through taxpayers. As taxpayers, we're expected to pay when there's a climate problem. These companies are making hundreds of billions of dollars.
One of them heard you.
Okay, did I freeze there for a second? I know
Yeah,
that
you're
you froze for me. We also need a conversation about how these impacts are harming us. You know, the poster child for the climate problem is the polar bear. But BC communities and communities all around the world are already suffering very real climate impacts. You know, the rising sea levels, wildfires, mountain pine beetles, drought, these are all things that have been experienced in BC communities around over the last several years, and they are generally attributable to climate change. And we need that conversation about these companies that are making hundreds of billions of dollars a year. We're bearing the cost. How do we square that? As long as we have an industry that doesn't think it needs to clean up after itself, we're not going to solve this problem. So we're talking about the ability of communities to come together to demand accountability from these companies. We're talking about that initially through a letter, through sending a letter to the companies, just asking them for their position on what their fair share is and whether they will commit to pay those costs. This is a powerful tool. I want to emphasize that we're talking today about litigation, but there are a lot of ways to create this conversation that are campaign tools that don't involve litigation, that involve just the price of a stamp and paper to send a letter asking these questions. But also, you know, ways that other, you know, picketing outside of an Esso station asking when are you going to pay your fair share, or other ways to raise this conversation. Litigation is an option, and I think ultimately one that we may well need to go to, and we are asking local governments to consider a class action. Because this is a legal discussion, what does that look like? We're asking about a class action by BC's local governments based in both public and private nuisance for their adaptation costs, so the costs of preparing for climate change, against some group of the fossil fuel companies. You know, I could go through this in more detail. I know we don't have much time, so I'm just going to focus on what this structure means for causation, which is the problem that everyone says, well, how are you going to deal with causation? When people say you can't prove causation in a climate case, they have in mind 2 or 3 different related problems. One is, can the harm suffered by the plaintiff actually be linked to climate change? I've written that wrong there. But can the harm suffered by the plaintiff actually be linked to climate change? If we focus on adaptation, it can. These municipalities are incurring costs. They are building higher seawalls. They are building bigger stormwater systems that can withstand bigger extreme weather events because their climate scientists are telling them this is what you need to do because of how your region is changing. The harm is very directly linked to climate change. Are the defendants' actions linked to climate change? Well, we're talking about a small number of companies. The top 5 companies are responsible for about 14% of the greenhouse gases in the global atmosphere. If you're looking at the top 20, it's about again, or maybe I've just frozen again. Okay, am I back?
Yeah.
The top 20 companies are responsible for about 30% of climate change, of the greenhouse gases emissions. And if you're able to sue for their proportionate share, you can definitely say that you know, for Chevron, 3.5% of the costs associated with that higher seawall is directly attributable to Chevron. We also believe that when we're suing in public nuisance, we can say that the act of degrading the global atmosphere is itself a nuisance. It's not the harm to the municipality that's the nuisance, it's that they degrade the global atmosphere. And there's case law related to water pollution that allows you to say, if you can measure the water pollution, that's significant enough that you can sue for it. Well, Chevron's contribution to the degradation of the global atmosphere is measurable. It's above what we can detect through the best scientific, well above what we can detect through scientific instruments.
Andrew, I'm giving you the 1 minute signal. Okay? Thanks.
Thanks. Okay. So basically, I think that structure of focusing on adaptation, focusing on the carbon majors, solves a lot of the problems we always hear about with causation and dealing with climate change. We can go into this in more detail in the Q&A. On the adaptation, local governments are already considering major expenditures associated with adapting to climate change. Last October, Vancouver considered whether to spend $800 million on a storm surge barrier to protect False Creek or $400 million to raise seawalls around the area. That's consistent with provinces' estimates that the region needs to spend $9.5 billion between now and 2100 to deal with rising sea levels. Small number of companies, we already talked about that. So I think that's it. I'll wrap up there. For more information, do check out the Climate Law in Our Hand. It says hand. It's supposed to be hands. ClimateLawInOurHands.org website or our West Coast Environmental Law website. And thank you very much.
Thank you, Andrew. That's an inspired concept, and I'm glad that what we started talking about a year and a half ago in this room, I think, is going somewhere. Thanks for taking that forward. And hopefully some municipalities will think it's in their interest to actually do something about this. Well, here's a man who's going to perhaps tell us we should help all together and go to court, and he's probably thought about how to do this more than many of us, and he's been in court more than most of us. Oh, yes, thank you. And just before I let him up here, if you've got questions that you want to ask the speakers, please make sure you hand in the cards to the students who are going to collect them now, I think, or in a minute. Go ahead. Thanks, Chris.
Thank you so much, David and Stepan and Dustin and the organizers. I'm really glad to have been invited here. Privileged to be on a panel with amazing lawyers and campaigners like this. This is really important stuff, and I thank you, all of you folks here and I guess listening to us elsewhere, for hanging in there. As you can see from the first slide, I anticipated being the last speaker that there would be some pressure to be brief, so I will, not pressure, but I'm going to try to be brief in any event. I want to first of all talk about a little bit about the intersection between the two topics here today that I want to talk about, litigation, and climate litigation in particular, and environmental assessment. This is the nexus. This is an intersection that I've been quite involved in over the last 3 or 4 or 5 years, I guess, working with students at the University of Victoria and elsewhere in a variety of regulatory and litigation processes. And out of that work, and it's a bit reminiscent, I suppose, of what Andrea was saying, out of that work, I became very committed to this idea of working with the next generation, helping them become strong enough, ready enough to take on the challenge that lies ahead in terms of dealing with this climate crisis. And so out of that came the idea, with a number of other litigators and law profs, of starting an organization, a purpose-built organization that would have that as its mission, basically training the next generation of young lawyers and law students in the litigation skills they're going to need to fight these battles. And that organization is CEL, the Pacific Center for Environmental Law and Litigation. It's an organization that now is about 8 months old, and it's already taken on what we think is an important climate litigation case, which I'm going to talk about. And in fact, the slide here depicts the location of this proposed project, which is at the mouth of the Skeena River, one of the continent's most productive and important salmon rivers. And in the foreground, you see Flora Bank, which is at low tide right now in this picture, but also for most of the year, a very important salmon habitat area. In the background, you see Leilu Island, which is going to be the location for this project. The current CEL team has also worked on some other climate-related litigation and regulatory work over the last few years. This kind of is the culmination of that work. So we worked on Northern Gateway, we worked on Kinder Morgan, and now we're working on this project, which is Pacific Northwest LNG. This project got its federal approval back in September from Cabinet. It is a mammoth project. It's a liquefaction project, which basically involves turning natural gas into LNG, liquefied natural gas, through a process of cooling that uses tremendous amounts of energy. And the energy comes from the natural gas, which in turn comes from the fracking fields in northeastern British Columbia, which many of you will be familiar with. 20% of the natural gas that ends up here will be burned to liquefy the natural gas so that it can be transported by tanker to Asian markets. As I said, this is a staggeringly large project. Its annual emissions will be 13 megatons. That's million tons of CO2 equivalent. That's including direct and upstream emissions. And to put that into perspective, that amounts to about 100%, that's 100% of BC's legal target for greenhouse gas emissions in the year 2050. This project went through a Canadian environmental assessment done by the agency. The agency properly concluded they really had no alternative to conclude that this was going to be a significant adverse environmental effect. These emissions would be significant. They put that in their report. That report went to Cabinet. Cabinet had to decide whether these emissions were justified in the circumstances within the terms of the Canadian Environmental Assessment Act, and that's exactly what the federal cabinet decided on September 27th. Our lawsuit, which also relates to salmon, I don't have time to talk about that, this lawsuit in terms of greenhouse gas emissions argues that the agency reached the right conclusion but failed to display proper reasoning, failed to indicate proper research to show how and why these emissions are significant. In order for Cabinet to discharge its duty to decide whether they could be justified in the circumstances, we say Cabinet had to have a report that was fulsome, robust, comprehensive, that explained how and why these, in the view of the agency, these emissions were significant. And the agency did not do that. This slide really, I guess, is a distillation of some of the lessons from the other cases, not just this case, but also Northern Gateway and Kinder Morgan. And I guess what we've learned from those cases is that in terms of the lexicon, in terms of the sort of conceptual framework of environmental assessment, regulators have to adapt. They have to look at this as a unique environmental problem. Unique in a variety of ways, because it's global, because it's irreversible, because CO2 as a greenhouse gas is, once released, is almost permanently, for over 1,000 years, in the atmosphere. And we say that the agency here completely failed to grapple with those aspects of the analysis, and for that reason basically deprived our cabinet of the information they needed to do their job, which means that the cabinet decision here is invalid. How much time do I have? Do I have time to talk about the obstacles and the tensions? Let me talk about them a little bit. I was going to skip over it to stay on a positive note. But let me just hit the obstacles before I hit the positives here. We have obviously, through the process of litigating these cases and working in the regulatory process, encountered lots of obstacles. Back in the day, during Northern Gateway, for instance, and in other processes, these regulatory agencies refused to actually assess climate impacts. And they continued to refuse to do so until they were told to do so by this new government under interim guidelines. That requirement has to be hardwired into law now. So that's an important thing that we need to stay on top of. Another issue that you will encounter as you litigate these cases is judicial deference, especially because of the scientific complexity and technical issues here. And I think that various of the speakers have underscored that what you have to tell the judge is when they are starting to feel uncomfortable is that that's your job. You have to deal with those and begin to understand those issues because that's where we are. And it is your responsibility to be able to learn how to manipulate and use those concepts within a legal framework. There is another problem that came up as a result of Northern Gateway, some of you will be familiar with as well, and that is the Federal Court of Appeals holding that assessment reports, like the one here in Pacific Northwest LNG, are not judicially reviewable, which came as a complete surprise to most of us who've been following this. For years, these kinds of reports have, in fact, been reviewed by federal courts. And for the Federal Court of Appeal to reach a contrary conclusion is pretty amazing. I guess the only solace is that that ruling only appears to apply to NEB-led assessments and not to the rest of the assessments that are being done. But hopefully that will be corrected in the law reform process that is currently rolling out. In my remaining time, I guess what I wanted to try to do, because I think this is very important given the challenges we're dealing with, I wanted to ask the question, why do we keep doing this, and what are the benefits? And I think a key benefit that isn't bulleted here is what Andrea has talked about, what I've alluded to, which is that we have a duty to equip the next generation with the tools to take on this challenge, to carry it forward when it's their turn. And in fact, in Andrea's case, I guess it is already their turn. So that's part of it. I think the other part is harm reduction. You've heard about that in other contexts. What we're trying to do in this case is, in other cases, is to reduce the harm by killing off bad projects or making bad projects a little bit less bad. One way this project could be made less bad would be not burning natural gas, emitting it into the environment, but instead hooking this project up to the grid. So a more fulsome and robust analysis of alternatives could have led to that requirement. As well, I think in these cases, I think what we're all trying to do is to spotlight the need for various government agencies, courts, and others to become conversant with the science, to step up to the plate and do their job. And I think that in litigation, that's basically what you're asking the courts to do. And whether they're comfortable with that or not is somewhat beside the point. And finally, just let me say this. There is a law reform process that you'll be familiar with that has been started by the federal government to look at environmental assessment. The other reason that these cases are important is that I think they all show the dire need for us to change the way we do environmental assessment in this country. And I think I'd like to think that all of you will leave here with a renewed interest in making sure that that happens. Thanks very much.
Thanks so much, Chris, for those very thoughtful insights, and leave us with some real challenges there. And I'm glad you're taking this case, and I can't believe what you told me about the Federal Court of Appeal, saying you can't judicially review panel reports, because as you say, we've been doing it for the last 20 years or something. Anyway, well, they need to get straightened out. Time for questions. We have some questions. The ones you gave me are from the audience, right. And if you have any others, the students are still collecting them. So let me, here's a question that might sort of more Canadian context, but I think, Andrea, from the U.S., it bears on on you. Will there be a barrier to legal challenges in countries where with no constitutionally protected right to a healthy environment, i.e. Canada, the person has stated? Maybe we should start with somebody from Canada to get a reaction to that, the assertion that, in fact, there is no right to a healthy environment in Canada. Maybe, Chris, do you want to say anything?
Well, I can start us off. I know Andrew has written on this as well. It is true that if you read the words of our charter literally, that isn't in there.
Right.
But those words can be interpreted to incorporate that. So I think there are lawyers who are thinking of ways to bring cases that will expand upon our conventional understanding of the charter. But the other thing, and I think this is in Andrea's, in the Juliana case, is that the judge talking about the public trust doctrine. Mm-hmm. And that's a doctrine that doesn't depend upon the Constitution. Right. That's a doctrine that, in a sense, as she indicated, is a feature of natural law. And I think that maybe I'll pass it over to Andrew, because I think that he's been writing about the public trust doctrine for a long time, and it'd be very interesting to see whether he thinks there's promise in terms of atmospheric litigation with respect to advancing the public trust doctrine.
Just bring back Justice Binney and Canfor. Okay, go. Andrew, did you hear the? Yeah.
Well, that was a good time because Chris froze, and that means I guess I froze, and I'm back just in time to get it passed off to me. So, I agree with Chris. The right to life. Clearly, when we're talking about fundamental issues going to the, there is as serious as climate change that are going to result in deaths, illness. The right to life can clearly be interpreted broadly enough to encompass many of those issues. The public trust doctrine it's always an interesting issue in Canada. I think that the Canadian courts have not yet developed that doctrine in a very significant way. But yeah, the Canfor decision, which I think is what you were talking about when I got frozen out, the Supreme Court of Canada certainly paid lip service to the idea that there could be government responsibility to the public for failing to protect the environment, and that's essentially what the public trust doctrine is.
Right. Well, they certainly left the door open, I think, to invited at the right time, and maybe there's some new members of the court that would be very interested in that. So, Andrea, just to another question, sort of interfaces between the last one and it's in the U.S. What is the interaction between constitutional claims and the public trust doctrine?
Yeah. Well, just to address briefly that last one, it's not a right to a healthy environment. I mean, we don't have that in Washington State. We don't have that in the federal Constitution. What the court said in our case, we have certain inherent rights that are preserved by the Constitution. So almost every state constitution, and I think a number of different constitutions, says that by entering into this document, you don't give up certain rights by signing this Constitution. That's what the judge hung her hat on in our case. So it wasn't a constitutional text. And then just think of it as a practical matter. Does a government have the right to sit by and authorize these projects while the territory of the government is being destroyed and will go away? No. So there has to be rights somewhere in the law, whether it's the public trust doctrine, whether it's other reserved areas of law. So it's there. We just have to look hard enough to find it. So what was the other part of the question?
Well, it was, what, if anything, do you see the interface between constitutional claims and the public trust doctrine?
Well, it depends on the jurisdictions. Sometimes in the states, the public trust doctrine is codified in the Constitution. It's written in there. In Washington, it's partially codified. But again, it goes back to what I said earlier, is that the public trust doctrine are rights that exist by virtue of the creation of the sovereignty. So they're rights that the legislature can't give away. They're different than what we call the police power, which is what gives legislatures the right to regulate certain conduct. So, it's preserved by the Constitution, either by explicit text or through the reserved rights doctrine. So there's a bunch of different ways to frame that, depending on the jurisdiction where you find yourself.
Okay, thank you. Here's a question that, for Rhoda. First of all, is there anything in the German Constitution that gives some hope of using that as a basis for environmental or climate change litigation? And a related question, I guess, is what barriers, if any, does the cap and trade system pose to trying to take litigation against emitters in Germany or other places in Europe that are governed by the ETS?
Mm-hmm. Well, yes, thank you. Well, the first question, I think, is not only limited to the German constitution, but to many constitutions in Europe. And it's basically that in theory and in the written text, you will find both the normal Charter of Human Rights, but you will always also find in the constitutional law jurisprudence by the constitutional courts or even the civil law courts in these European countries, such as mine, that there is a duty to protect on behalf of the state. And so I've always said that, yes, in theory and maybe in practice, these kinds of cases will be possible in Germany or in other countries where you have similar kinds of constitutions. The problem is not so much the written text or the theory. The problem is that the courts, due to the separation of power doctrine, are reluctant to actually regulate like that. And that was, for me, the main surprise with respect to the Ogenda case in the Netherlands, because actually the constitutional framework in the Netherlands and Germany is quite similar. So our constitutional court, which is really a pretty good one, I would say, has always said that there's a very large margin of discretion for the legislator to make use and fulfill its duty of protection. So the question really is, what is the threshold for the duty of protection in this particular case? And that's what we'll have to find out, I think. And the second question, the cap and trade system. Well, basically, the cap and trade system, ever since 2009, has rendered it legal to emit carbon dioxide in Europe and in many, states in the US or even here or Switzerland. So basically, what we can no longer argue is that the activity itself is actually illegal or, fulfills any kind of fault standard. And that doesn't mean that a nuisance type case like mine is not possible. And that's something that I think is also something that hasn't quite filtered through, because nuisance isn't dependent on fault. It's actually about whether or not the impact, that's our theory anyway, whether the impact is unbearable on the victim.
Right. Well, thank you for that. It sounds like if you're relying on the European concepts of human rights to some extent, the right to life is about where we're at in the Canadian Charter of Rights, and both in Europe and here, we'd have to push the courts to accept that environmental and climate change should come under that. It doesn't seem to be a problem for the judge in Pakistan, and he got it pretty quickly. So here's a question for Keith, and there's a couple of them. First of all, how have the Canadian carbon majors responded to the Philippines human rights complaint and request for information and submissions in particular? And I suppose the corollary question from somebody else is, what has been the impact of the Filipino government on climate change, knowing that their human rights record is poor?
So on the first point, the 4 Canadian companies have chosen not to reply. So no response from them so far. We'll be pressing them to respond, and they will eventually be invited to public hearings, which will probably take place in the fall. And we'll encourage them to show up in the way Greenpeace likes to encourage people.
Okay.
In our typically helpful and understated manner.
Right.
In terms of so the second question was
what's been the impact of the new Filipino government, I take it, on climate change, knowing?
Yeah, so there has been a change in government in the Philippines. The new president has an interesting approach to crime and human rights.
Yeah.
And he got elected on a platform of he would kill all the drug dealers. So it's one of the reasons that the process has been delayed is because the Human Rights Commission itself is dealing with many issues. And so part of the way they deal with that is they order the plaintiffs, us, to do some of the work, like, you have to send out these things to the companies, and but they are committed to sort of following through on this. Mm-hmm. The new president is I mean, it's not unlike Trump in that he's difficult to predict. But he just recently, when he came in, he first said, you know, I'm going to pull out of Paris, and was sort of quite aggressive towards climate action. But he has recently said Philippines will sign the Paris Agreement, and he seems to be coming around. So I think one of the interesting things is, you know, for a country like the Philippines, this is pretty much all risk, no reward in terms of climate impacts. They don't have a strong fossil fuel domestic sector, yet they are suffering some of the worst impacts. And I think that's very clear to many people in the Philippines, and I think it's going to help, in many countries, to sort of build public support because they see the damages that they're facing.
Yeah, thank you for that. You know, I was in Lima for the previous one before Paris COP, and ended up sitting on the bus beside Canada's climate change ambassador, and he said, "Darn," he said, "there's another typhoon coming through the hurricane at this COP just like there was last year. How did they arrange it?" Well, he didn't quite ask it that way, but that was the inference. You know, that this was something they had done to get attention on having to do something about climate change, when the Harper government in particular didn't want to even acknowledge the fact that it existed.
And the former Filipino climate negotiator, Yeb Sanyo, is now actually the executive director of Greenpeace Southeast Asia.
Well, that's great. So here's a question. It sounds, for whoever wants to talk about it, it sounds like many of the panelists are requesting court-managed climate change mitigation and adaptation strategies. Have you experienced reluctance on the part of the judiciary to assume this management role as opposed to declaratory relief? What arguments can be made to make these management-type remedies more palatable to the courts? So maybe, Andrew, do you want to start off on that?
Yeah, you know, I think the closest we got in relief was in our Washington case. And in that case, she ordered them to do the agency to do a rule capping and regulating carbon dioxide emissions. And she was very clear that she wasn't instructing them on how to do that, just that it needed to be done. We asked that she required it to meet some standards, but she didn't do that. Then they did a cap and trade rule, which is awful, and she regretted not having required them to do standards. And so she granted us leave to amend our complaint so that our case is more broad, because she recognized, I think, that by just allowing them to continue to exercise their discretion, they cannot do it. And in her most recent order, she said, there's an urgent need for science-based action to address climate change. So in our case, you know, she went through what normal judges would do through the process, is, you know, give the government the opportunity to do it right. But that's why it's so important to have a court-ordered and supervised remedy, because they're not going to get it right. They cannot get this done without courts requiring them to do that. So in the federal case, our remedy is a climate recovery plan, in essence. But we are going to put on a significant amount of evidence in terms of what should be in it, because, you know, we need these courts to recognize that it's feasible to reduce emissions in line with what's required by best available science. So some of our experts will be on the feasibility issue, and we will present one example of what the United States government could do to put us on a path towards climate recovery. Whether the judge will implement our plan or something else, time will tell. But judges are inherently uncomfortable with that, but I think what we will see is they'll recognize that they have to do it. And we saw that with desegregation of schools. The early cases said you got to desegregate schools, figure it out. Never could be done. And so the courts ultimately said, you do it by this date in this manner. And I think that's where we will get with climate change cases. So ask for it now, but it's going to take a while to get there.
And the Supreme Court of Canada upheld a decision, a Charter of Rights case in Canada that said there wasn't enough French schools in New Brunswick, and the court and the trial judge ordered the school board or whatever to report back to him on their progress in getting to what they needed to do. And the government appealed that all the way to the Supreme Court of Canada, saying, no, courts, there's no right to supervise. Once you made your decision, that's it. Your role is done. The Supreme Court of Canada very clearly said that's not right. Courts can make orders and have a right to follow up and have a right to make sure that their orders are respected and followed. And we'll do whatever it takes. It's been done in history. It's done through courts of equity. And it's analogous to what happened, I think, in the anti-segregation cases in the United States. So the Supreme Court was very clear, our Supreme Court, thank goodness, if we ever get to a remedy that can be enforced. One more question. What somebody wants, okay, here's a question, a little off the legal stream. Can you speak to fundraising for these cases? What method works best? How much enthusiasm have you found? Any other thoughts? Anybody want to tackle that?
Our experience is you have to go for it with your cases, and then our fundraising, it's all through donors or grants. We don't have any other, we don't have any other financial backing other than that. But, I think we had a grant for our Washington case. I think we had one grant for $2,000, and we've been litigating the case for 2.5 years. So, we can do things on a shoestring budget.
but what our Children's Trust has done is enlist a whole bunch of lawyers on a pro bono basis to bring these cases.
Yes, and we have a tremendous team, and the scientists, the scientists they oftentimes are willing to provide their expertise on a pro bono basis as well, because they see the planet that they love and the things that they study going away. But fundraising is an important aspect of it, and nobody used to like to fund litigation. It was kind of not fun to fund, but I think these days, because of the politics of it all, I think they're recognizing that we've got to fund litigation because that's really where we're at. So hopefully that tide is turning.
And I think in Canada, it goes double, that basically getting money to fund public interest litigation, even critical litigation, is very hard to do. But I would echo what Andres just said, is that that shouldn't prevent you from starting these cases, from gathering together your teams, recruiting scientists who are very willing to work on these cases without being paid. I think that you build it and they will come. The funders will come to the cases that are making a difference, to the organizations that are out there doing good work. And that's always been my experience over 20 years doing this, and it continues to be. I'm not a great fundraiser, but I like to think I'm good at building organizations that funders like to support.
Thanks. Rhoda, did you want to say anything on
that? Just that in Germany there is no such thing as kind of a history of funders coming and funding litigation. There is no such thing. So this case is entirely funded by private donors, really. And that is apart from a very small grant from a foundation. But what I find more interesting is really the amount of support that I've gotten pro bono from science as well. Because I have not spent a single euro on a scientist. And that is, it's incredible how they actually want to support much. I mean, I couldn't actually even officially speak to all the people that wanted to be involved, because if I speak to too many people, these will no longer be impartial witnesses for the court. So, but I mean, it's really incredible how this is soaked up. And I have to relay maybe one thing that makes it really important that we lawyers also go and speak to science more often. I had the opportunity to speak at a couple of actual science conferences, IPCC scientists wanting to know what these law cases are all about. So I spoke about, about your case, my case, about what you just said. I just kind of conveyed the importance of the science in this. And I actually read bits and pieces of some of the judgments on the IPCC, and they were, I mean, you could literally see the scientists actually getting goosebumps because they had no idea about their own importance. And that's something that's also very important to me about this climate litigation, that you actually interact this way with the science community and they actually know what a huge important role they're playing.
Yeah. Those are very good and important thoughts. Are we pretty well out of time for? Yeah, well, would you want to come on up and say something? Well, Diane Sachs everybody knows who Diane is, and she's Ontario's Environmental Commissioner, but she's had a remarkable career in environmental law. Dr. Diane Sachs.
Stop.
Okay, all right, go ahead. Okay.
I know it's late. I was supposed to be already finished by now. I did actually put some slides together, but I don't think we've got time to go through them. But, yeah, you okay? Oh, all right. Well, so I need the clicker or whatever. But I guess I have to go down there. All right. So what I wanted to say. Okay. It is very hard to get regulators, politicians, judges to get serious and feel that they actually have power to deal with harm that may occur to other people in other places later. And that is most of the time what we're talking about with climate change. And it's true that climate change is going to be worse for other people in other places later. But and it's much easier for judges, and you've heard most of what I wanted to say, these lovely people have already said, but it's much easier for judges and regulators and politicians to deal with concrete harms to real people who are alive now here. So I don't know whether it's good news or bad news, but we have that now. And I encourage you to go beyond the IPCC and look at the developing science about what is actually happening, sort of where we are. So I spend a lot of time, I'm on a crazed circuit at the moment, going to senior decision makers, both in and outside the government, basically taking people by the lapels and shaking them and saying, you are not worried enough about climate change. You still think normal is coming back. You're still using evidence-based decision-making based on the average of the 20th century, and it's not right anymore. And that shocks people. Now, I am shocked that they're shocked, because I think I'm telling them very old news, and I've done this now, I don't know, 45 times, and I have yet to leave a room where people weren't, right? So, and of course, there's so much more locked in, right, from the emissions that we've already had, and this is also something people rarely understand. But in terms of finding concrete evidence of things that judges can understand, stuff about money, judges understand, right? So the actuaries' climate index, what could be more boring than actuaries? And they have crunched all these numbers, and this is Canada and the United States. So there actually is more and more evidence out there about specifically what is happening here. That's Canadian catastrophic insured losses. That's just the insured losses, right? So the total losses you have to assume are going to be basically double that. You can get a lawsuit out of that, right? Because that's money and that affects everybody. And that's just what's happened already. So the insurance companies understand it. It also helps, I think, if you're thinking, and I'm talking about Ontario, right? My jurisdiction's Ontario, is looking at the very localized work that's being done at places like York University. Well, LAMPS has this project. Now, one of the fun things about LAMPS is they are fabulous with data, but they only want to speak in mathematics. So you really have to work to coax out of them something the lawyer might understand. But they have enormous amounts of data. And so one of the fun things is if you look, that doesn't work. Anyway, you see there's a blue spot in the middle over here? Right. So there's places, there are some places in Ontario where the frost-free season has not grown in a generation. But the whole rest of the province is. Why is that? Well, if you pay attention, it's the topography. So the impacts can be really localized. There are places where you're seeing 13 additional days of frost-free growing season every decade. And there's places where there's none. So the IPCC stuff is great, but A, it's a little bit out of date, in some ways importantly out of date, and B, it's not localized. And to get litigation that a judge will feel comfortable with and that regulators can deal with, it's very helpful to be local. And there is more and more evidence out there, but you just sort of have to hunt for it. In Ontario, we already have, we have a lot of impacts. We already have like the loss of the ice roads, which is huge, causing enormous damage in the north. We're going to have, you can see the drought map from last year. Health impacts are on their way. That's also something the judges can feel comfortable with. Ministry of Health did quite a good report last year on health impacts in Ontario, and they have told absolutely nobody about it, but it is on their website. I'll skip a batch of other stuff. I mean, I presume you've all seen this horrible thing about the sea ice loss, which is truly stunning. But getting judges to understand that so much has already changed, right? It is too late to have anymore the world that I grew up in. And there is the evidence for this. So that, I think, is concrete enough, and especially if you can also bring home to them there is very, very, very short window to make a difference between a world that is different but manageable and a world that isn't. So law and lawyers matter, I think, a lot. Now, Ontario's doing a lot that's right, and also, of course, they're doing lots that's terrible, and so you'll see in our report we say lots of things they're doing that are terrible, but it is also very important that they get some recognition and support for the things that they are doing that is right. It is incredibly important. Politicians are humans, and worse than that, they are very dependent on approval humans, right? Because that's why they went into politics. So it matters enormously if they hear from people, preferably in person, what you care about. And the more they hear from, the better. So, you know, your grandmother's sewing club, your daughter's skating club, any number of people, if you can get them to go to constituency offices and speak to politicians. How many people here have, in the last 5 years, spoken to a political representative about climate change? Okay, so there's a few people here. The rest of you, be inspired by these folks. I can't tell you how important it is. Politicians really, really get influenced by who talks to them. So that there's a whole batch of other stuff here. You've all seen. I hope you've all seen this, the spiral. But the gist, the most important thing is to speak up. Lawyers, we can and should be climate leaders. Lawyers as professions, not those in this room, but lawyers as professions, we're a big part of the problem. We're disproportionately large fossil fuel users, and we disproportionately serve people who benefit from the status quo. But we can also be a big part of the solution. By definition, we're educated, we're articulate, we know more than most people about this, how the system actually works, and we have access to the levers that actually make a difference. Litigation is one of the things it does, and whether or not any particular case succeeds, you can start moving the needle, make things that companies have to disclose to financial regulators, make things that deputy ministers have to get briefed on, make the kind of media storm that we've seen in some of these cases, and you can allow other things to happen. So lawyers, you got a lot of work to do. Thank you.
Well, we're just about finished the program tonight. We're so grateful to all of our panelists for participating. We'd like to give a special thanks to Rhoda, who came from Europe, and Andrea, who came from the west coast of the U.S. We're grateful to Chris for coming from the west coast of Canada, and Andrew for participating remotely from there. Before we have just a final remark, I wanted to say for anybody who is attending by webcast who wants to receive CPD credit for this event, you may have noted that some of you may be participating via anonymous webcast, others may be registered. So we just, to be sure, if you want to receive credit, please send an email to me, swood@osgoode.yorku.ca, and we'll make up a list so that if it ever needs to be checked, we will have it on record. And I'd like to also thank Dustin Clout, who is an LLM student at Osgoode and a member of the Bar of BC, non-practicing, but very active in many issues related to human rights, constitutional law, and climate change, who has been the main logistical organizer of this event. Let's give him a round of applause. Thanks also to the students at the Environmental Justice and Sustainability Clinic who helped us out this evening with registration and collecting the questions. Thanks to everybody who came out on a Monday evening and listened and posed very interesting questions, which I think could have kept us busy for another hour. And with that, let's have a round of applause for our speakers once more. Thanks very much. Good night.